Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. New Mexico. It's been a while. How are you doing? Hey, listen, I haven't forgot about you. I was kind of standing there quietly on the sideline watching your governor run amok. And we have, as you know, geeked out on the fact that several months ago, Michelle Lujan Grisham believed that there was a public health emergency so grave, so severe, that she had the authority to sua sponte suspend the Second Amendment rights of hundreds of thousands of New Mexican residents. Of course, that led to all sorts of litigation, and away we went. Well, I have said that this is the governor that won't quit, and she wouldn't quit, but she has finally run into a bit of a brick wall. So today, let's spend a few minutes and let's talk about when the court has to tell your governor to shove it. Okay, New Mexico, this is the case we're talking about today. It's the case of Springer v. Grisham. This is one of many challenges to Governor Michelle Lujan Grisham's gubernatorial order where she sua sponte suspended the Second Amendment rights of everybody in the city of Albuquerque as well as the surrounding county. Now, as we know, there were certain parts of that order that were stripped down right away by the courts, but there are other parts that kept going around. Now, one of the other things I said to all of you down in New Mexico, and I was speaking from experience here in Washington State, is that this had come out as a public health emergency, a gubernatorial order on a public health emergency. Where have we ever seen that before? Well, and then I drew on my own experience because living up here in the People's Republic of Washington, we had a public health emergency a few years ago where our governor promised us 15 days to flatten the curve, and he shut down the whole state. Now, I said to my wife at that time that I was not going to get a haircut until our kids ended up going back to school, and at one point I ended up looking like this. That's right, because after almost 900 days, the governor finally released most of his emergency power. Now, what we've seen here with Governor Michelle Lujan Grisham is every month when the order's about to expire, she just says, oh, the public health emergency continues and therefore I'm going to extend the order. I haven't seen one iota of data to suggest that the emergent situation, if it existed to begin with, still exists. I have not been seeing any new data from the state of New Mexico that tells me you were doing any worse than you were prior to this. And we do see gun violence and violent crimes increasing exponentially across the country for multitudes of reasons, predominantly, well, you know, the defunding of our police departments. The two issues that were challenged here in Springer was Governor Grisham's prohibition on firearms in parks and in playgrounds. And this ended up before the United States District Court for the District of New Mexico. And the judge here has enjoined the order on parks, okay? So the restriction on parks has been enjoined. However, the restrictions on the playgrounds still remain in effect. I'm going to explain to you how the judge did this real quick. We'll geek out on the opinion real quick. Let's get right to it. So the court basically starts off its ruling this way. Defendants have not satisfied the test set forth in Bruin at this stage, and they have not demonstrated a historical tradition of prohibiting the carrying of firearms in public parks. The court therefore enters a preliminary injunction enjoining the public health order to the extent it prohibits carrying firearms in public parks in Bernalillo County and Albuquerque, New Mexico. But when it comes to playgrounds, the court here has found that playgrounds are essentially tantamount to other sensitive places in which we have a historical tradition of restricting firearms. The court specifically ruled, however, the court declines to enjoin the public health order to the extent it prohibits firearms in playgrounds. Plaintiff has not demonstrated standing to enjoin the firearm restrictions in playgrounds. Even if he had, the government has demonstrated that playgrounds are analogous to sensitive places where there is a long-standing history of firearm regulations. Now, one of the arguments that the state of New Mexico made in trying to oppose this injunction is that there was actually a higher level of proof that the plaintiffs needed to show here. I want you to be aware of this, New Mexico, because you may see this in other cases where the government's going to argue the same thing. The court here soundly rejected that there was any additional burdens of proof for the plaintiffs to meet. Therefore, a heightened standard does not apply here. Nevertheless, the court finds that plaintiff satisfies even the heightened standard as to his request to enjoin the restriction on carrying firearms in public parks, as explained below. Now, you guys have all geeked out on this channel long enough to know that if we're asking for an injunctive relief, or if we're asking for the court to hit a big old pause button, we got to show two things. Number one, we got to show that we will be irreparably harmed, that we are likely to suffer irreparable harm. The second thing we have to show is that we're likely to prevail on the merits. And that is why when a plaintiff obtains injunctive relief, it can be a very, very positive sign. Now, there is a litany of case law out there that says, listen, if you're violating a constitutional right in general, then we will presume that to be irreparable harm. So again, we're talking about the violation of one's Second Amendment rights. This activity is clearly covered by the plain text of the Second Amendment. So the court's willingness to enjoin this law is incredibly positive because it also shows the court believes that the plaintiffs are likely to prevail. As the court put it, as explained below, plaintiffs have shown a likelihood of success on the merits as to the Second Amendment claim challenging firearm restrictions in public parks, as defendants have failed to carry their burden to show a historical tradition of banning firearms in public parks or their historical analogs. The state of New Mexico, unlike other states, at least conceded that the activity in question here is covered by the plain text of the Second Amendment, which means we just then move to the second part, which is, can the government justify this through some type of historical analog? The court ruled as follows. As to the second step, defendants have failed to carry their burden of demonstrating a historical tradition of firearm regulation in public parks. The burden on the merits in a preliminary injunction proceeding tracks the burden at trial. Now, one of the cases that the state of New Mexico relied on heavily is a case called Maryland Shall Issue Inc. versus Montgomery County. This was a similar challenge to a lot of sensitive area restrictions in the state of Maryland, and the Maryland court had upheld that. However, the court was very wise to point out that, yeah, all of that was upheld pre-Bruin. Now we have to take an entirely different look on that, and once we do that, well, we don't come to the same result. In conclusion, the court summarized its ruling as follows. In sum, defendants provide no evidence illuminating the scope of the Second Amendment right at or around the time it was adopted. Constitutional rights are enshrined within the scope they were understood to have when the people adopted them. As to the 14th Amendment, defendants presented insufficient evidence illuminating such understanding. The vast majority of defendant citations come at least 20 years after the enactment of the 14th Amendment, which the Bruin decision only considered to the extent it was consistent with earlier law. Because defendants failed to carry their burden to establish a historical tradition of firearm regulation in public parks, the court concludes that plaintiffs are likely to succeed on the merits. Okay, that is really good news, but like I mentioned, not everything was rosy, because although the restriction on public parks was struck down, the restriction on playgrounds was not. The court, in summary, ruled as follows. Defendants have demonstrated a historical tradition of restricting firearms in sensitive places analogous to playgrounds. The court further stated, even assuming plaintiff has standing to challenge the restriction on firearms in playgrounds, the court would not enter an injunction in his favor, as defendants have demonstrated that playgrounds are sensitive places where there is a long-standing historical tradition of firearm regulation. So, New Mexico, the restriction that your governor placed, sua sponte, by the way, all on her own, on you carrying firearms in public parks, that now has been enjoined. The restriction on playgrounds remains in effect. The case, once again, is Springer v. Grisham. We will link it up down below so you can geek out on it for yourself. In the meantime, if you got any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. If you don't, that's okay. That information is down there in the description box as well. In the meantime, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.